My wife couldn't balance a checkbook. She's a clerk, a government clerk. She filed papers for 15 years while I built an empire. Now she wants half of what she never understood? The words echo through courtroom 4B of the Los Angeles Superior Court. Garrett Ashford stands at the witness stand, Armani suit perfectly tailored, silver cufflinks catching fluorescent light. His attorney, Prescott Lane, leans back in his chair with the satisfied posture of a man who has already won. At the plaintiff's table, a woman in a plain navy blazer sits motionless. No jewelry except the wedding band California law requires her to wear until the decree finalizes. Her attorney, Victor Okonkwo, makes a note but doesn't object. Garrett had just called his wife of 15 years a government clerk in open court. He had no idea she was documenting his $8.7 million fraud. The gallery murmurs. A woman in the third row, Miranda Cole, Garrett's executive assistant, covers a smile with manicured fingers. The judge, Roland Mercer, watches with the practiced neutrality of 28 years on the bench. Mr. Ashford, Prescott Lane continues, can you describe for the court your wife's involvement in your financial affairs? Involvement? Garrett laughs. The sound carries contempt like a weapon. There was no involvement. I handled everything. The investments, the properties, the tax planning. Marlene signed where I told her to sign. That was the extent of her contribution. If you're enjoying this story, hit that subscribe button and the notification bell so you don't miss what happens next. Marlene's pen moves across her legal pad. Not notes. Calculations. 3 columns of numbers that don't match numbers that should match numbers that can't possibly be true. She circles one figure, underlines it twice, then writes 4 words in the margin. Cayman National Bank. Verified. Prescott Lane approaches the witness stand with a document. Your Honor, I'd like to enter into evidence Respondent's Exhibit 14, Mr. Ashford's Financial Disclosure Form FL-142, filed under penalty of perjury. Judge Mercer nods. The clerk stamps the document. Lane reads aloud, his voice carrying the rehearsed confidence of a man who bills $800 an hour. Total liquid assets, $847,000. Total real property equity, $1.2 million. Total retirement accounts, $340,000. I declare under penalty of perjury, under the laws of the state of California, that the foregoing is true and correct. Signed, Garrett R. Ashford. $2.387 million. That's what Garrett claims he's worth. Marlene adds a 4th column to her calculations. The real number sits in her briefcase, documented across 3 years of careful observation. $8.7 million hidden across 4 countries. Garrett catches her writing and smirks. He thinks she's taking notes like a dutiful student trying to understand concepts beyond her comprehension. He has always assumed her silence meant ignorance. Her patience meant weakness. Her calm meant surrender. 15 years of marriage, and he never once asked what she actually did at her government job. No further questions, Your Honor. Lane returns to his seat. Victor Okonkwo rises. 43 years old, public defender background, suit slightly worn at the elbows. The kind of attorney wealthy men like Garrett dismiss on sight. Mr. Ashford, you testified that your wife had no involvement in financial decisions. Is that correct? That's what I said. Did she have access to your bank accounts? Joint accounts only. Household expenses. And the business accounts? Garrett's jaw tightens. Those are separate entities, LLCs, S-corps, complex structures she wouldn't understand. So she had no visibility into your business finances? None. Victor makes a note. No further questions. Judge Mercer checks the clock. We'll recess for lunch. Court reconvenes at 1:30. The gallery rises. Garrett steps down from the witness stand and walks directly to Miranda Cole, who hands him his phone with a touch that lingers slightly too long. His attorney follows, already strategizing for the afternoon session. Marlene doesn't move. She sits at the plaintiff's table, pen still in hand, studying her legal pad. The calculations form a story that contradicts everything Garrett just testified to under oath. Victor leans close. Marlene, we need to talk strategy. Not here. They gather their materials and exit through the side door, away from the gallery's curious eyes. The hallway smells like floor wax and old justice, the particular scent of a building where lives are dismantled according to procedure. Victor's office is 3 blocks away, above a bail bondsman and across from a check-cashing store. The elevator doesn't work. They climb 4 flights in silence. Inside, he closes the door and turns to face her. He's destroying you on the stand. Lane's going to paint you as a gold digger who contributed nothing to the marriage. I know. You don't seem concerned. Marlene sets her briefcase on his desk, opens it, removes a folder thick enough to be mistaken for a manuscript. I need you to file a motion to compel full financial disclosure, international accounts specifically. Victor stares at the folder. Marlene, we already filed that motion. Mercer denied it, said it was overly broad and unduly burdensome. File it again, with this. She opens the folder. The first page is a bank statement. Cayman National Bank, account holder, Ashford Holdings, LLC. Current balance, $3,847,221. Victor's face goes pale. Where did you get this? Marital property access, California Family Code Section 1100. Spouses have equal management and control of community property. That account was funded with community assets. How do you know it was funded with? Because I tracked every deposit for 3 years. She flips to the next page. Wire transfer records, source accounts, routing numbers, dates. Pacific Ridge Development, that's the company Garrett claimed was underwater in his disclosure, transferred $450,000 to the Cayman account in January alone. Victor sits down heavily. The chair creaks under sudden weight. He pages through the folder, each document more damaging than the last. Shell company registrations, beneficial ownership filings, tax returns that contradict sworn statements. This is comprehensive. It's accurate. Marlene. He looks up at her. How did you compile all this? These are forensic-level documents. Chain of custody notation, hash verification. This isn't research. This is a case file. She meets his gaze steadily. I'm thorough. You're more than thorough. You're trained. The word hangs between them. Trained. It implies things neither of them is ready to discuss in a rented office above a bail bondsman. File the motion, Marlene says. Include exhibits A through F. Save the rest for trial. The rest? There's more. Much more. But we need them to commit to their lies first, fully, on the record, under oath. Victor closes the folder, studies the woman sitting across from him, the woman he'd initially assessed as another victimized spouse, another casualty of a wealthy husband's midlife crisis. That assessment was shifting rapidly. Who are you, Marlene? I'm your client. She stands. And right now, that's all you need to know. 14 months earlier, the morning sun streamed through kitchen windows in the Ashford residence, a 6,000-square-foot Mediterranean revival in Pacific Palisades. Marlene stood at the counter, coffee mug in hand, watching condensation form on the glass. The clock read 5:45. Her running shoes waited by the door. Her work bag sat packed on the entry bench, files organized by case number, laptop fully charged, credentials secured in the inner pocket where she always kept them. Garrett's keys jangled as he descended the stairs, already dressed for a meeting she hadn't been told about. Early flight, he said by way of explanation. Miami. Back Thursday. Miami. The 3rd trip this month. She noted the pattern without comment. Safe travels. He grabbed an apple from the bowl, didn't kiss her goodbye, and walked out the front door. His Porsche started in the driveway. Tires crunched on gravel. Then silence. Marlene waited 3 full minutes before moving. Confirmed he wasn't returning for forgotten items. Then she walked to his home office. The door wasn't locked. Garrett had stopped locking things years ago, confident in his wife's disinterest in business matters. She'd cultivated that disinterest carefully, asking just enough questions to seem dutiful and not enough to seem curious. His desk was organized chaos, contracts awaiting signature, architectural renderings for developments she'd never been told about, correspondence with attorneys whose names she didn't recognize. Normal clutter for a man who believed his empire was invisible to his invisible wife. The envelope was misfiled, stuck between a property assessment and a utility bill, as if someone had shuffled papers hastily and shoved it wherever it would fit. Foreign postage, Cayman National Bank, Georgetown, Grand Cayman. Addressed to Ashford Holdings, LLC, an entity she'd never heard of in 15 years of marriage. She photographed the envelope, then the statement inside. Account number, routing information, transaction history, all of it captured in high resolution, time-stamped automatically by her phone's camera. She returned everything exactly as found. Left the office. Closed the door. Started running. 6 miles through the canyon trails, her pace steady and her mind cataloging. Not the betrayal. She'd suspected that for years. The financial betrayal. The hidden accounts. The shell companies. The lies signed under penalty of perjury every April when they filed joint tax returns. Her husband was hiding assets. Significant assets. The question was why? Tax evasion was the obvious answer, but Garrett wasn't stupid enough to leave evidence where she could find it accidentally. Unless the accident wasn't accidental. Unless he was testing whether she paid attention. She paid attention. She'd been paying attention since the day they married. That evening, she created a new email account, non-attributable, routed through servers that didn't log user data, started a spreadsheet that would grow over 3 years into the folder now sitting in Victor Okonkwo's office. Garrett returned from Miami with a tan and a receipt she found in his jacket pocket. Zuma Restaurant, Miami Beach. Reservation for 2. Dated the same evening he'd claimed to have working dinners with investors. She photographed the receipt, added it to the file, said nothing. Documentation wasn't revenge. It was protection. She'd learned that difference a long time ago. 3 weeks after the Cayman discovery, the Ashfords hosted a dinner party. 12 guests, catered food, wine that cost more per bottle than some families spent on groceries for a week. The gathering served Garrett's networking needs, real estate contacts, potential investors, the social lubrication that kept his empire expanding. Marlene played hostess, smiled at appropriate moments, guided conversation away from politics, made sure glasses stayed full and egos stayed stroked. Miranda Cole arrived late, overdressed, and attached to Garrett's arm before the first course was served. "Marlene, darling," Miranda air-kissed both cheeks. "That dress is so vintage. Is that what they're calling thrift store chic these days?" The comment landed in the brief silence between conversations, audible to everyone within 6 feet. "Target, actually," Marlene said. $40, pockets deep enough to hold my phone." Miranda's smile flickered. She hadn't expected engagement. Women in Marlene's position usually wilted under public criticism, apologized for their inadequacy, retreated to safer corners of the room. Marlene didn't wilt, didn't apologize, just stated facts and moved on. Later, near the dessert course, Miranda found another opening. "Garrett, you should take your wife shopping sometime. Or does government salary not allow for that?" Garrett laughed. Not a corrective laugh, a collaborative one. "Marlene prefers practical. Don't you, sweetheart?" Sweetheart. The endearment weaponized, said in a tone that made practical sound like pathetic. "I prefer useful," Marlene replied. "Clothes that work, bags that hold files, shoes I can run in if necessary." "Run from what?" Miranda's eyes glittered with malice disguised as curiosity. "Traffic." Marlene smiled. "Los Angeles is unpredictable." The exchange ended there, but the dynamics were established. Miranda as Garrett's ally, publicly dismissive, likely privately involved. Garrett as complicit, choosing his assistant's mockery over his wife's dignity. Marlene filed it all away. Not emotionally, operationally. Witnesses, patterns, evidence of the marriage's dysfunction that would matter when documentation became litigation. After the guests left, she cleaned the kitchen in silence while Garrett reviewed emails on his phone. He didn't offer to help, hadn't offered in years. "Miranda's efficient," he said without looking up. "I'd be lost without her." "I'm sure." "She thinks you don't like her." "I don't think about her at all." Garrett glanced up then, something flickering across his face. Surprise, perhaps, or suspicion. His wife's responses had grown less predictable lately, less accommodating. He filed it away as hormones or midlife dissatisfaction, the categories where he stored all female behavior he didn't want to examine closely. Marlene finished the dishes, dried her hands, and went upstairs to the home office she maintained separately from his. The door locked from the inside. The computer required biometric access. The files were encrypted with protocols that would take state-level resources to crack. She added tonight's observations to the timeline. Miranda Cole, executive assistant, likely affair. Public humiliation with spousal complicity. The spreadsheet grew longer. The folder grew thicker. The marriage grew thinner. And Garrett noticed none of it, because Garrett had never looked closely at his wife. Not once in 15 years. Not when she'd taken the government job he dismissed as beneath her. Not when she'd declined promotions that would have required travel and visibility. Not when she'd insisted on filing taxes jointly, giving her legal access to records he assumed she'd never read. He saw a clerk, a placeholder, a woman who existed to sign documents and host dinner parties. He had no idea what she actually was. The truth about Marlene's real identity will shock you. Make sure you're subscribed so you don't miss the reveal. The country club event 3 months later cemented the pattern. Garrett introduced Marlene to a circle of investors without using her name. "My wife," he said, gesturing vaguely in her direction while maintaining eye contact with the men who mattered. "What do you do?" one of them asked politely. "Paperwork," Garrett answered before she could speak. "She pushes paperwork for the government. Someone has to, right?" Laughter. Male laughter, the kind that bonds through shared condescension. "Actually," Marlene said, "I work in financial analysis, pattern recognition mostly, finding discrepancies that don't belong." Silence. The investors looked at Garrett, uncertain whether his wife had just been clever or combative. "Tax stuff," Garrett said quickly. "Auditing. Very boring." The conversation moved on, but Marlene caught one of the investors studying her with new interest. The kind of assessment that recognized competence even when it was being actively dismissed. She filed his face away too. Gerald Hoffman, real estate attorney, Garrett's lawyer for the Malibu development deal. 2 months later, Hoffman's name appeared on a document she found in Garrett's desk. A power of attorney granting Ashford Holdings LLC authority to open accounts in the British Virgin Islands. Gerald Hoffman had witnessed the signature. He knew about the shell companies. He was helping. The financial lockout happened 6 months before filing. Marlene asked about the Cayman account, calmly, directly, without accusation. "You're reading things you don't understand," Garrett said. His voice carried the patient condescension of a teacher explaining basics to a slow student. "It's a business structure. Legal. My accountant handles it. Why are you snooping through my things?" The deflection. The blame reversal. Classic patterns she recognized from training manuals she'd studied for entirely different reasons. "I found it misfiled in the household bills. I wasn't snooping." "You were in my office." "Looking for the water bill. The city sent a shut-off notice." Garrett's jaw tightened. The water bill excuse was plausible. She'd arranged for the notice to arrive that week specifically, knowing she'd need cover for her observation. "Stay out of my business papers, Marlene. You wouldn't understand them anyway." 1 week later, the joint account password changed. Credit cards in her name frozen for review. Bank access restricted to a household account with a $5,000 monthly limit. The text arrived at 3:47 p.m., while she sat in her office reviewing case files for work she actually did. Change the accounts. You don't need access to everything. I handle finances. You handle the house. That's how this works. She screenshotted the message, forwarded it to the encrypted email account, added it to the timeline with date, time, and context notation. Then she called the bank, not to complain, to document. I need to file a formal inquiry regarding account access changes made without my authorization. The phrasing caught the customer service representative off guard. Formal inquiry, not complaint, not request, the language of someone who understood procedures. Ma'am, the primary account holder has authority to... I'm a joint account holder. Under California Family Code Section 1100, both spouses have equal management and control rights of community property. Please document that I'm disputing these access restrictions and note my objection in the account file. Silence on the line, then typing. I've noted your objection, ma'am. Is there anything else? Yes. Please send me written confirmation of all account changes made in the last 7 days. Mail it to my attention at our home address. The documentation arrived 4 days later. Garrett never mentioned it. Either he didn't notice or he assumed she couldn't interpret the banking language. She interpreted every word, cross-referenced it with his financial disclosure from 2 tax seasons prior, found the discrepancy that would eventually matter, an account number referenced in the change documentation that didn't appear anywhere in their joint tax filings. Another hidden account. Domestic this time. Chase Bank, Manhattan branch. She added it to the spreadsheet. Called the branch directly, not to access the account, which would be illegal without proper authorization, but to confirm its existence as community property. I'm verifying an account associated with my Social Security number. Can you confirm whether account number ending in 7741 shows me as an authorized party? The confirmation took 3 minutes. No, she was not authorized. The account was held solely in Garrett R. Ashford's name, opened in 2019, 3 years into their marriage. Community property law meant that account belonged half to her, regardless of whose name was on it. Garrett didn't know she knew. He'd never know until the courtroom, until the moment it mattered most. Victor Okonkwo's office became headquarters for a campaign Garrett never saw coming. The first meeting established the stakes. Victor's honesty was either refreshing or depressing, depending on perspective. Mrs. Ashford, I need to be honest. Your husband's attorney has never lost a divorce case. Prescott Lane builds reputations on destruction. He's going to hide assets, delay proceedings, and try to bankrupt you through legal fees. Are you prepared for that? I'm prepared for exactly that. Something in her tone made Victor pause, recalibrate, look at her differently than he'd looked at any client before. You sound like you've done this before. I've seen it done, to other people, for a long time. He studied her face, searching for context she wasn't providing. The calmness didn't fit. Spouses facing Prescott Lane usually arrived terrified, already defeated by the attorney's reputation before the first filing. This woman sat in his worn office chair like she was running a meeting, not seeking help. What exactly do you do for the government, Mrs. Ashford? Financial analysis? Pattern recognition. The same answer she'd given at the country club. Technically true, strategically incomplete. And you believe you can out-document Prescott Lane? I know I can. Victor leaned back. 20 years of family law had taught him to recognize certain things. Desperation looked one way, grief looked another. This woman showed neither. She showed something closer to operational patience, the specific calm of someone executing a plan rather than reacting to circumstances. All right, he said finally. Let's see what you've got. She opened the briefcase she'd brought, removed folder 1 of what would eventually become 17. Victor started reading, stopped after the 3rd page, looked up at her with an expression that mixed professional admiration with personal alarm. You've been documenting for 3 years? Since I found the first discrepancy. And he doesn't know? He thinks I can't balance a checkbook. Victor almost smiled. Almost. Why me? You could afford Lane's firm yourself with documentation like this. Why hire a public defender turned solo practitioner? Because Lane would recognize his own tactics. He'd know something was wrong. You're outside his radar, outside his expectations. He'll underestimate you the same way Garrett underestimates me. That's a strategy. That's the strategy. Victor closed the folder, made a decision that would define the next 14 months of his career. File the divorce petition, standard grounds. Irreconcilable differences. We don't show them anything they don't already expect. And then? Then we wait. Let them build their case on lies they think are safe. And when they've committed, fully on the record, under oath, we show them the truth. Marlene nodded. How long? 12 to 18 months if they fight it. They'll fight it. Good. She stood, shook his hand, and walked out into the Los Angeles afternoon. Victor sat at his desk for a long time after she left, staring at the folder that would eventually grow into a box, then a filing cabinet, then a case that would make legal journals. He still didn't know exactly who she was. He was starting to suspect he'd find out in a way that would change everything. The deposition happened 4 months after filing. Prescott Lane's conference room occupied the entire 27th floor of a Century City high-rise. Glass walls, modern art, furniture designed to intimidate through expense. Marlene sat in a chair that cost more than her car. Her suit was off the rack, serviceable, deliberately unremarkable. She wanted to look exactly like what they expected, a government clerk out of her depth. Lane began his questioning with practiced aggression, the kind of tone that made witnesses defensive, emotional, prone to mistakes. Mrs. Ashford, you claim to not understand your husband's business. Is that because you're incapable of understanding, or because you chose not to care? The question was designed to trap. Either answer damaged her credibility. Neither, she said. I understand my husband's business quite well. I'm stating that he excluded me from financial decision-making. Lane's eyes narrowed slightly. The answer was too precise, too calm. You understand his business? Can you name 3 of his current development projects? Pacific Ridge, Sunset Holdings, the Malibu Marina proposal. She met his gaze without blinking. The first is allegedly underwater. The second reported a loss of $200,000 last quarter, and the third is pending Coastal Commission approval that was delayed in September due to environmental concerns. Silence. Even the court reporter stopped typing for a moment. Lane recovered quickly. You've done research. I read the business journal. And yet you claim your husband excluded you from financial matters. Reading public filings isn't the same as participating in decisions. The distinction was legally relevant, and Lane knew it. He shifted tactics. Mrs. Ashford, have you had any contact with your husband's business associates during the marriage? Define contact. Conversations, emails, phone calls. I've attended social functions where his associates were present. We've had small talk at dinner parties. Any substantive discussions about business matters? Marlene paused. The pause was calculated, long enough to seem thoughtful, short enough not to appear evasive. His accountant, Chandler Knox, once asked me about my work. And what did you tell him? That I work in financial analysis for the federal government. Lane made a note. Probably irrelevant, his expression suggested. Just a clerk making her job sound more impressive than it was. No further questions at this time. Miranda Cole sat in the corner of the conference room, ostensibly as a potential witness, but actually as Garrett's emotional support. She'd been smiling throughout the deposition, savoring Marlene's apparent discomfort. As Marlene gathered her things to leave, Miranda leaned toward Garrett and whispered, loud enough to be overheard by everyone in the room, "She's drowning and doesn't even know it." Marlene didn't react, didn't change expression, just walked to the door with Victor, who carried the briefcase that held documentation Miranda Cole would never see coming. In the elevator, Victor exhaled. That went better than expected. It went exactly as expected. Lane thinks you're harmless. Good. Let him think that all the way to trial. The elevator descended 27 floors. Marlene watched the numbers tick down and calculated timelines. 14 months to trial, give or take. Thousands of pages of documentation to organize. Dozens of lies to catalog. Garrett thought he was winning. Lane thought victory was inevitable. Miranda thought the drowning woman couldn't see the surface. They were all wrong, and by the time they realized it, the water would be closing over their heads instead. The media campaign began 8 months before trial. Garrett's PR team, a resource Marlene hadn't known he employed, placed a feature in the Los Angeles Business Journal. The article painted him as a victim of marital greed, a self-made developer whose charitable work was being overshadowed by an ungrateful spouse. The headline read, "Developer Ashford focuses on philanthropy amid personal challenges." The subtext was clearer. Vindictive wife trying to steal wealth she didn't earn. Marlene read the article in her office, her real office, the one with the federal seal on the door and the case files that had nothing to do with her marriage. Sources close to the family describe Mrs. Ashford as paranoid and financially illiterate, the article stated. Mr. Ashford's generous community involvement stands in stark contrast to his wife's apparent inability to appreciate the complexity of real estate development. She clipped the article, scanned it, added it to the file with a notation. Public narrative establishment. Character assassination via proxy attribution. Note phrase, complex real estate holdings, potential relevance to disclosure claims. She didn't respond publicly, didn't issue counterstatements, didn't feed the media cycle that Garrett's team had manufactured. She added documentation instead. The PR firm's invoice, which she found in their joint tax file during a review she was legally entitled to conduct. The communications between Garrett and the journalist, obtained through a Freedom of Information request when she discovered the reporter had previous contact with city officials on development permits. Everything connected, everything documented, everything waiting for the moment when documentation became devastation. The discovery motion failed. Victor filed for full financial disclosure, international accounts specifically. Lane opposed with a brief that cited burden, relevance, and harassment. Judge Mercer sided with Lane. The ruling arrived by mail, formal language that translated to defeat. Respondent shall produce bank statements for domestic accounts only. Request for international banking records denied as overly broad and unduly burdensome. Petitioner has failed to demonstrate relevance of alleged offshore holdings. Victor called with the news, apology heavy in his voice. "I'm sorry, Marlene. Mercer didn't buy the relevance argument." "I expected that." "You expected to lose." "I expected them to block the standard route. That's why we have the alternative." Silence. Then, "What alternative?" "The documents I've already obtained through marital property access. The ruling says we can't compel production through discovery. It doesn't say we can't introduce evidence we legally obtained on our own." Victor took a moment to process. "You're going to ambush them at trial." "I'm going to present evidence at trial. Evidence they don't know exists. Evidence that contradicts their sworn statements." "That's risky. That's strategy." He could hear her shuffling papers on her end of the line, always organizing, always preparing, always 3 moves ahead of whatever game Lane thought he was playing. "Marlene, I have to ask again. What exactly did you do before you worked in financial analysis?" "I've always worked in financial analysis, Victor. Just not always for the government you're imagining." She hung up before he could ask the follow-up questions burning in his mind. Choke. The night before trial, Marlene reviewed her documentation one final time. 3 years of evidence, 17 folders, 4 countries' worth of hidden assets. Shell companies traced through ownership chains that most attorneys would need forensic accountants to unravel. She didn't need forensic accountants. She was the forensic accountant, among other things. Her credentials sat in a locked box in her closet, the badge she hadn't worn in 14 months, the identification card that could open doors Garrett didn't know existed. GS-14, Internal Revenue Service, Criminal Investigation Division. 17 years of service, specialized in international tax fraud and financial crimes. She'd thought about revealing the truth earlier, using her position to accelerate the investigation, leveraging federal resources to tear apart Garrett's empire before he could move assets. But that would have been a conflict of interest, a violation of everything she'd sworn to uphold. The line between personal vengeance and professional duty was bright and clear, and she would not cross it. Her documentation was personal, conducted on her own time, using only resources any spouse could legally access. No federal databases, no agency cooperation, nothing that couldn't be explained as a suspicious wife protecting her interests. The irony wasn't lost on her. Garrett thought she was financially illiterate. He'd married one of the most effective fraud investigators in the Western region and never once thought to ask what financial analysis actually meant at the federal level. Tomorrow, the trial would begin. Tomorrow, Lane would present his case built on lies. Tomorrow, Garrett would testify about assets that didn't exist and poverty that was manufactured. And somewhere in the next 2 weeks, when they'd committed fully to their fraud, she would show them who they'd actually been married to. The badge stayed in the box. The folders stayed organized. The woman who'd been called a clerk adjusted her plain navy blazer and prepared to look exactly as helpless as they expected. Trial day 1 opened with Lane's confident presentation, Garrett as the aggrieved husband, Miranda as the supportive colleague, a narrative of marital drift and unreasonable demands. Victor's cross-examination was careful, probing, designed to plant doubts without revealing strategy. Each question pulled threads that would unravel later. Mr. Ashford, you testified that Pacific Ridge Development reported losses last year. Can you specify the amount? Approximately $200,000. And those losses are documented in company filings? Yes. My accountant can provide. We'll request those documents. Thank you. Lane objected to relevance. Mercer overruled. The thread remained attached, waiting to be pulled. Marlene watched from the plaintiff's table, studied Garrett's body language, the confidence that bordered on arrogance, the certainty that his lies were safe because his wife was stupid. He glanced at her occasionally, smirked sometimes, performed outrage at other times when Victor's questions approached uncomfortable territory. He had no idea she was cataloging every performance, noting discrepancies between testimony and documentation, building the cross-examination that would destroy him. Day 2 brought witnesses. Character witnesses for Garrett, business associates who praised his integrity, neighbors who admired his philanthropy. Miranda Cole herself, testifying about Garrett's generous nature and Marlene's aloofness. She never seemed interested in his success, Miranda said from the stand, makeup perfect, sympathy calculated. Almost like she resented him for achieving things she couldn't understand. Victor's cross was brief. Ms. Cole, how would you describe your relationship with Mr. Ashford? Professional. We work closely together. How closely? Lane objected. Relevance, Your Honor. This isn't about my client's professional relationships. Sustained. Move on, Mr. Okonkwo. Victor nodded. No further questions. The question lingered anyway. Jurors, if this had been a jury trial, would have noticed the hesitation. Mercer noticed it too, making a note that might not matter legally, but mattered personally. Day 3 introduced the document that changed everything. Lane approached the bench with theatrical solemnity. Your Honor, I'd like to enter into evidence respondents Exhibit 27, a spousal agreement signed by Mrs. Ashford in 2019, waiving her rights to business assets acquired during the marriage. Marlene's stomach didn't drop. Her expression didn't change, but her mind raced through implications she'd anticipated but hoped wouldn't materialize. They'd forged a document. They were actually stupid enough to forge a document. Victor's objection was immediate. Your Honor, we've never seen this agreement. It wasn't produced in discovery. It was in secure storage, Lane said smoothly. My client forgot about its existence until recently. We're producing it now in the interest of full disclosure. The irony of full disclosure from a man hiding $8 million would have been amusing if it weren't so dangerous. Judge Mercer examined the document. "Mrs. Ashford, do you recognize this agreement?" "I have never seen it before, Your Honor." "The signature appears to match your known signatures." "Then it's a forgery." Lane smiled, the smile of a man who thought he'd sprung an inescapable trap. "Your Honor, we request a brief recess to allow Mrs. Ashford to examine the document. Perhaps her memory will improve." "Granted. 30 minutes." Victor and Marlene retreated to a conference room. The document sat between them like a bomb. "They forged it," Victor said, voice tight with anger and worry. "They actually forged a document." Marlene studied the agreement, ran her fingers along the paper, examined the signature with the eye of someone who'd spent a career detecting exactly this kind of fraud. "It's sophisticated," she admitted, "but there are tells." "What tells?" "The paper stock, the notary seal, the signature pressure." She pulled a magnifier from her bag, always prepared, always equipped, and examined the document more closely. "Victor, I need you to request production of the original document, not this copy." "Lane will fight it." "Let him." California Evidence Code Section 1521. When authenticity is disputed, the court can require production of the original. Victor drafted the motion on his laptop, filed it electronically. Lane's response came within minutes. Objection, burden, original in secure storage requires 7 days to retrieve. Judge Mercer's ruling split the difference. 7-day continuance. Mr. Lane, produce the original document or withdraw the exhibit. Trial day 3 ended with the fraud suspended in legal limbo. Marlene spent those 7 days reviewing her documentation again. Not to find new evidence, she already had everything she needed, but to organize the presentation, the sequence, the timing. If they produced a forged original, she would destroy it on the stand. If they withdrew the exhibit, she would wonder why they'd exposed themselves by introducing it at all. Day 8 of trial arrived with the original document in Lane's hands. Marlene watched him present it to the court with the confidence of a man who'd bet everything on a bluff. The paper looked aged appropriately. The signature looked genuine to untrained eyes. The notary seal bore the weight of official authentication. Victor requested examination time. 30 minutes granted. In the conference room, Marlene unpacked tools she'd brought specifically for this moment. Magnifying glass, UV light, reference materials on paper stock and notary commission dates. "You came prepared," Victor observed. "I anticipated fraud. Forged documents are Lane's specialty when other tactics fail." "And you know how to detect forgeries?" She didn't answer directly. "Look at the notary seal. Commission number 2287441. Victor examined it. "Looks legitimate." California notary commissions follow a specific numbering sequence. That commission number wasn't issued until March 2021. The document is allegedly from 2019. Silence. Victor stared at the document with new eyes. "They made a mistake." "They made several. The paper stock is Hammermill Premium, 24-pound weight. That specific watermark code, HM2022, wasn't manufactured until 2022. And the signature—" She traced the lines with professional precision. "The baseline pressure is inconsistent with my known signature patterns. There's a tremor pattern suggesting traced reproduction rather than natural signing motion." Victor sat back. "You're an expert in document forensics." "I'm knowledgeable." "Marlene." His voice carried the weight of questions he was finally ready to ask directly. "You analyze documents professionally. You track financial patterns for a living. You anticipated forged documents and brought detection equipment to trial. Who are you?" She met his eyes. The moment stretched. "I'm your client, Victor, and today I'm going to destroy their case on the stand." Court reconvened. Judge Mercer looked at Lane, then at Victor, then at the document in the court clerk's hands. "Have the parties reached any stipulation regarding the document's authenticity?" "No, Your Honor," Victor said. My client disputes the document's authenticity and requests permission to address the court regarding her expertise in document examination. Lane's smile flickered. Your Honor, Mrs. Ashford is not a qualified expert witness. California Evidence Code Section 720 allows any person with special knowledge to testify as an expert, Victor countered. Mrs. Ashford has specialized training in document analysis. Mercer considered. Mrs. Ashford, what is your background in document analysis? Marlene stood. The moment had arrived, not the full reveal, but the beginning, the first crack in the wall of assumptions that had protected her throughout this trial. Your Honor, I've worked in financial analysis for the federal government for 17 years. Part of that work involves identifying fraudulent documents, forged signatures, and falsified financial records. Lane's expression shifted. Something moved behind his confidence, the first flicker of uncertainty. I'd like to present my preliminary findings regarding this document, if the court permits. Judge Mercer nodded. Proceed. Marlene approached the witness stand for the first time as something other than a passive party. The gallery watched. Garrett watched. Miranda Cole watched with the dawning realization that something had changed. The document presented as Respondent's Exhibit 27 contains multiple indicators of forgery. She held up the magnifier. First, the paper stock. Hammermill Premium, 24-pound weight. Watermark code HM-2022. This paper was not manufactured until 2022. The document is allegedly dated 2019. Murmurs in the gallery. Lane's jaw tightened. Second, the signature analysis. The baseline pressure is inconsistent with my known signature samples. There's a tremor pattern suggesting traced reproduction rather than natural signing motion. This indicates copying rather than original execution. Judge Mercer leaned forward, suddenly very interested. Third, the notary seal. Commission number 2287441. California notary commissions follow a sequential numbering system. That specific commission number was not issued until March 2021. This document could not have been notarized in 2019 because the notary's commission didn't exist yet. Absolute silence. Conclusion: this document is fraudulent. It was manufactured no earlier than 2022, forged with my signature, and submitted to this court as authentic evidence. Lane rose, face flushed. Your Honor, these are unsubstantiated allegations. Mrs. Ashford is not a court-certified document examiner. Mr. Lane, Judge Mercer's voice carried steel. Your client submitted a document allegedly signed in 2019. That document contains a notary seal that couldn't have existed until 2021, printed on paper that wasn't manufactured until 2022. Would you like to explain that? Lane looked at Garrett. Garrett looked at the document. The silence stretched into disaster. Your Honor, we request a recess to consult with our client. Denied. Sit down, Mr. Lane. Mercer's gaze swept the courtroom. This court takes fraud seriously. The submission of forged documents constitutes contempt. I'm ordering an evidentiary hearing on this matter, separate from the divorce proceedings, to determine whether sanctions under California Code of Civil Procedure, Section 128.7, are appropriate. The gavel fell. Trial adjourned for the day. But the damage was done. Garrett Ashford had bet his credibility on a forged document. His wife had destroyed that document in under 3 minutes, using expertise he never knew she possessed. What Marlene reveals next will change everything. Subscribe now and turn on notifications so you don't miss Part 2. Outside the courthouse, Victor turned to Marlene with an expression that mixed triumph with bewilderment. You knew they'd forge a document. I suspected. Lane's reputation includes creative evidence when standard tactics fail. And you prepared for this specific forgery? I prepared for any forgery. The details were Lane's choice. Victor shook his head. Marlene, I've practiced law for 20 years. I've never seen anyone dissect a document like that on the stand. That wasn't preparation. That was expertise. It was both. Are you going to tell me who you really are? Marlene looked back at the courthouse. Through the glass doors, she could see Garrett in animated conversation with Lane, the argument between client and attorney when defeat replaces confidence. "Soon," she said. "Very soon. But first, I need them to make one more mistake." "What mistake?" "They introduced a forged document, Victor. That's fraud on the court. But it's not the biggest fraud they've committed. For that, I need them to double down on their financial disclosure, to testify under oath, again, that they've fully disclosed all assets. And then I show them exactly what I found." Victor processed this. "You're setting a perjury trap." "I'm presenting evidence. If that evidence contradicts their sworn testimony, that's their problem, not mine." "That's cold. That's justice." Marlene started walking toward the parking structure. "He called me a clerk who couldn't balance a checkbook, Victor, in open court, in front of witnesses. He's been hiding money from me for years, while publicly humiliating me for being financially incompetent." "And?" She stopped, turned to face him. "And I'm going to take everything he hid, every dollar, every account, every shell company he thought I couldn't find. And when I'm done, the only thing he'll have left is his signature on a forged document that's going to follow him for the rest of his career." Victor had no response to that. They walked to their cars in silence. 3 days later, the evidentiary hearing on the forged document concluded with findings that made Lane sweat through his Armani suit. Judge Mercer's ruling was direct. The document submitted as Respondent's Exhibit 27 is hereby determined to be fraudulent. Mr. Ashford and counsel are sanctioned $50,000 under Section 128.7. Additionally, I'm referring this matter to the State Bar for potential ethics violations. Garrett's face went pale. Lane's went red. Miranda Cole, sitting in the gallery where she shouldn't have been, looked like she'd swallowed something poisonous. But the divorce trial wasn't over. The forged document was dead, but Garrett's financial disclosure remained unchallenged. His testimony about assets, the lies he'd told under oath, still stood in the record. Trial Day 9 opened with Victor's most aggressive cross-examination yet. "Mr. Ashford, you testified previously that your total net worth is approximately $2.387 million. Is that correct?" "Yes." "And you testified that Pacific Ridge Development, your largest holding, is currently underwater, running losses." "That's correct. The market has been difficult." "You filed that claim under penalty of perjury." "I did." Victor held up a document. "I'd like to introduce Petitioner's Exhibit 43, a wire transfer record from Pacific Ridge Development to an account at Cayman National Bank dated January of this year, amount transferred $450,000. Lane rose immediately. "Objection. This document wasn't produced in discovery." "Your Honor, this document was legally obtained through marital property access under California Family Code Section 1100. The petitioner has equal management and control rights over community property. She was not required to produce it in discovery because she did not obtain it through discovery." Mercer studied the document, looked at Garrett. "Mr. Ashford, do you recognize this wire transfer?" Garrett's confidence was cracking now. The forged document disaster had shaken him. This new evidence was shaking him more. I'd need to consult with my accountant to—" "A simple question, Mr. Ashford. Did Pacific Ridge Development transfer $450,000 to an account at Cayman National Bank in January?" Garrett looked at Lane. Lane stared at the document like it was a snake in his briefcase. "I believe so." "You believe so. And this transfer occurred while you were testifying under oath that Pacific Ridge was underwater and running losses. The Cayman account is a business structure, legal tax planning. Legal tax planning that you failed to disclose in your FL 142 financial declaration?" Silence. Judge Mercer set down his pen. "Mr. Ashford, I'm going to ask you directly. Did you disclose all assets, domestic and international, in your sworn financial declaration?" Garrett's mouth opened, closed, opened again. "Your Honor, my accountant handles the complex structures. I may not have had complete visibility into every—" "Yes or no, Mr. Ashford. Did you disclose all assets? The courtroom held its breath. Marlene watched from the plaintiff's table, expression neutral, pen ready to document whatever he said next. To the best of my knowledge at the time, yes. To the best of your knowledge. Mercer's voice carried the weight of a judge who'd seen thousands of lies in 28 years. We'll see about that. He turned to Victor. Continue, Mr. Okonkwo. Victor smiled, the smile of a man who was just getting started. The afternoon session introduced 3 more exhibits, each one a body blow to Garrett's credibility. Exhibit 44, a bank statement from Zurich Merchant Bank. Account holder, G.R. Ashford Trust. Balance, 1.85 million Swiss francs. Exhibit 45, beneficial ownership filings for Beacon Trust, British Virgin Islands, named beneficiary, Garrett R. Ashford. Exhibit 46, a corporate registration for Ashford Holdings, LLC, Grand Cayman. Date of incorporation, 2018, 1 year after their marriage. Principal, Garrett R. Ashford. Registered address, a law office that specialized in asset protection for high-net-worth individuals. Each document came with the same explanation. Marital property access, community assets used to fund these accounts. Legal right to documentation that exposed illegal concealment. Garrett's testimony devolved from confident denial to stammering qualification. Lane's objections grew increasingly desperate. Miranda Cole left the courtroom after Exhibit 45, unable to watch the empire she'd helped build begin to collapse. By 5 p.m., Judge Mercer had seen enough. We'll recess until tomorrow, but I want to be clear about what I'm observing. He looked at Garrett with the expression judges reserve for people who've insulted their intelligence. The financial disclosure you filed with this court appears to have omitted approximately... How much, Mr. Okonkwo? Approximately $6.33 million in undisclosed community assets, Your Honor. Mercer let that number hang in the air. $6.33 million, hidden in offshore accounts, while testifying that your wife was financially illiterate and demanding half of assets you claimed were only $2.387 million. Garrett said nothing. There was nothing to say. Tomorrow, Mrs. Ashford will have the opportunity to present her evidence fully. And Mr. Ashford, Mercer leaned forward, I strongly suggest you consult with counsel about how you want to proceed, because right now you're looking at far more than an unfavorable divorce settlement. The gavel fell. Court adjourned. But everyone knew the real trial, the trial of who Marlene Ashford actually was just beginning. That night, Marlene sat alone in her apartment, the modest 2-bedroom she'd rented when Garrett changed the locks on the marital home. The furniture was IKEA. The walls were bare. The lease was month to month because she hadn't known how long she'd need it. Her briefcase sat on the kitchen table. Inside, 17 folders of documentation. 3 years of patience. 15 years of marriage reduced to paper evidence of fraud. Her credentials lay beside the folders. Badge number 4. 4127. IRS, Criminal Investigation Division. The career she'd built before she met Garrett, during their marriage, and would continue after he was gone. Tomorrow, she would reveal everything. Not just the hidden assets, those were already exposed, but her identity, her expertise. The reason a woman Garrett called a clerk had dismantled his empire in 5 days of trial. The badge caught the light. 17 years of service, hundreds of cases, billions of dollars in fraud prosecuted, and Garrett had never once thought to ask what his wife actually did. She poured herself wine, drank it slowly, thought about the 15 years she'd spent watching, waiting, documenting, about the dinner parties where she'd smiled through insults, the country club events where she'd been introduced without a name, the slow erosion of dignity that came from loving someone who saw her as furniture. She didn't regret the marriage. Regret implied wishing things had been different, and things couldn't have been different. Garrett was who he'd always been, ambitious, controlling, certain of his own superiority. She'd just taken longer to accept that reality than she should have. What she regretted was the time. 15 years of pretending to be less than she was. 15 years of smiling when she should have left. 15 years of patience that might have been stubbornness in disguise. But the patience had paid off. Tomorrow, Garrett would learn who he'd been married to. Tomorrow, the judge would see the full scope of the fraud. Tomorrow, the lies would collapse under evidence that couldn't be dismissed or forged or explained away. Tomorrow, Marlene Ashford would stop being invisible. She finished the wine, set the glass in the sink, went to bed early because sleep was evidence preservation for the mind, and tomorrow required a clear one. The badge stayed on the table, catching light from the street lamp outside. Tomorrow. Bevou. Trial day. 10 opened with electricity in the air. The gallery was fuller than previous days. Word had spread about the forged document, the hidden accounts, the wife who'd dismantled her husband's testimony piece by piece. Reporters occupied the back rows. Divorce proceedings were public record, and this one had become interesting. Lane sat at the defense table with the hunched posture of a man awaiting execution. Garrett sat beside him, face gray, eyes avoiding his wife across the aisle. Victor rose when Judge Mercer called the room to order. Your Honor, petitioner requests permission to present concluding evidence regarding the undisclosed community assets. Proceed. Victor looked at Marlene, nodded once. She stood, smoothed her plain navy blazer, walked to the front of the courtroom with the folder that would end everything. Your Honor, I request permission to address the court regarding my specialized expertise in this matter. Lane stirred. Your Honor, Mrs. Ashford presented document analysis evidence earlier this week. What additional expertise? Let her speak, Mr. Lane. Marlene opened the folder, removed the credential wallet she'd carried for 17 years, set it on the evidence table. My name is Marlene Ashford. I am a GS-14 special agent with the Internal Revenue Service, Criminal Investigation Division. The courtroom went silent, completely, utterly silent. Badge number 44127, 17 years of service. I specialize in forensic document analysis and international tax fraud. Garrett made a sound, half gasp, half sob. The sound of a man watching his last hope disappear. I've spent 3 years documenting my husband's hidden assets, not as a federal investigation, that would be a conflict of interest, but as a spouse exercising her legal right to understand community property. Every document I've introduced was obtained through marital property access under California Family Code Section 1100. Every piece of evidence was gathered personally, on my own time, using methods any concerned spouse could legally employ. She held up the credential wallet. The clerk approached, verified the badge against federal databases, and nodded to Judge Mercer. Credentials verified, Your Honor. Active status. 17 years of service. Mercer looked at Marlene for a long moment. Something shifted in his expression. Not surprise exactly, but recognition. The pieces falling into place. The thoroughness of her documentation, the precision of her analysis, the calm that never wavered under Lane's attacks. Agent Ashford, he said finally, continue. And Marlene did. The next 2 hours were a masterclass in forensic presentation. She walked the court through shell company structures, beneficial ownership chains, and wire transfer patterns that revealed the full scope of Garrett's fraud. $8.717 million hidden across 4 countries. 17 separate accounts. 3 shell companies designed specifically to evade disclosure requirements. She explained how she'd documented without accessing federal resources, how she'd maintained the wall between personal investigation and professional duty, how she'd anticipated every objection Lane might raise and prepared evidence to counter it. And she read the evidence aloud, document by document, receipt by receipt. The same thorough, methodical presentation she'd given in 100 federal trials now turned against the man who'd called her a clerk. From the Knox-Ashford email correspondence, dated February 3, 2023. Subject line, R.E. Cayman structure. Quote, Garrett, transfer complete. The holding company now shows 0 U.S. connection. Beneficial ownership buried under 3 layers. Even if she finds an account, she can't prove you control it. Delete this after reading. End quote. Garrett flinched at every word. He did not delete it, Marlene continued. My automatic email forwarding captured it before he could. Lane's objections grew weaker as the morning progressed. By noon, he'd stopped objecting entirely. The final document came after lunch. Your Honor, I want to be clear about why I maintained professional boundaries throughout this process. She held up a letter on IRS letterhead. This is a conflict of interest review from the IRS Office of Professional Responsibility, dated March 15, 2024. I requested this review myself to ensure that my personal divorce proceedings would not compromise any federal investigation. She read aloud. This office has reviewed Special Agent Ashford's personal divorce matter. S.A. Ashford properly recused herself from any official investigation touching her spouse. Her documentation of marital assets was conducted in personal capacity using only legally accessible marital records. No conflict of interest finding. Case closed. The document went into evidence. One more nail in a coffin that was already sealed. Judge Mercer set down his pen, looked at Garrett, looked at Lane, looked at the mountain of evidence that had accumulated over 10 days of trial. Mr. Ashford, he said, do you wish to present any rebuttal evidence? Garrett didn't respond. Couldn't respond. He sat at the defense table like a man who'd just watched his life burn down. Lane stood instead. Your Honor, we request a continuance to review this new evidence and consult with... Denied. Mercer's voice carried finality. You've had 14 months to disclose accurate financial information. You submitted a forged document to this court. Your client testified under oath about assets he knew to be hidden. There will be no continuance. He straightened his papers. The ritual that preceded judgment. This court will issue its final ruling tomorrow morning. All parties will appear at 9 a.m. The gavel fell. Court adjourned, and Garrett Ashford finally understood who he'd been married to. Outside the courthouse, Marlene stood in the afternoon sun with Victor beside her. You knew, he said, from the very first meeting. You knew how this would end. I knew how it needed to end. Execution required patience. 17 years. Victor shook his head. 17 years as a federal agent, and he thought you were a clerk. He saw what he wanted to see, what made him comfortable, what reinforced his belief that he was the smart one in the marriage. And you let him believe it. I documented while he believed it. There's a difference. They walked toward the parking structure. Tomorrow's ruling would determine asset division, but the outcome was already clear. Garrett had committed fraud on the court. His financial disclosure was perjured. His credibility was destroyed. Under California law, when one party deliberately misrepresents community assets, the court could award 100% of undisclosed assets to the innocent spouse. $8.717 million. 100%. Tomorrow, Marlene Ashford would receive everything her husband had hidden. Everything he'd accumulated while calling her financially illiterate. Everything he'd built while treating her as furniture. What happens to him? Victor asked. After the divorce. Marlene considered the question. Judge Mercer will refer the case to the DA and the U.S. Attorney. Perjury charges are possible. Tax evasion under Title 26 is likely. His accountant is already cooperating with federal investigators. Separate investigation. Nothing to do with me. So he might go to prison. He might, or he might plead to lesser charges and pay fines. The federal system is unpredictable. She paused at her car. But he'll never practice real estate development again. His reputation is destroyed. His assets are gone. His affair partner is probably deleting texts right now. That sounds like justice. That sounds like consequences. She opened her car door. Justice would require him to understand what he did, why it was wrong, how it hurt people. Garrett will never understand any of that. He'll blame me for the rest of his life. Tell everyone who'll listen that his federal agent wife entrapped him." "Did you?" Marlene looked at Victor directly. "I documented crimes he was committing. I presented that documentation in court. If that's entrapment, then every fraud investigation I've ever run was entrapment. It's not the same." "No," she agreed, "it's not. This one was personal." She got into her car, drove away from the courthouse where tomorrow she would officially become a wealthy woman. But wealth wasn't why she'd done it. Dignity was why she'd done it. Garrett had spent 15 years making her invisible. Tomorrow, she would be impossible to ignore. End of Part 1. Tomorrow, Judge Mercer delivers his verdict. But Garrett Ashford has one final card to play, and what happens next will shock everyone in that courtroom. Part 2 reveals the full justice cascade and the twist nobody saw coming. Viết tiếp cho tôi phần 2, khoảng 11.500 từ, nội dung liền mạch cho đến hết câu chuyện. 16 giờ 22 phút. Lập kế hoạch tiếp tục câu chuyện với các yếu tố căng thẳng và kết thúc. The user wants me to continue writing part high of the story, approximately 11,500 words, seamlessly continuing from part 1 until the end of the story. Let me review what happened in part 1 and what needs to happen in part 2 according to the outline. Part 1 covered Hook, Garrett's humiliation in court. Setup, background of the marriage, documentation process. Inciting incident, financial lockout, decision to file. Escalations, deposition, media campaign, discovery battle, forged document. Partial reveal, Marlene's expertise in document analysis. Day 10, full credential reveal as IRS. Special Agent Part 2 needs to cover. Judge Mercer's final ruling, 100% asset award. Justice cascade, sanctions, referrals. Aftermath and unresolved threads. Stinger with DL connection. Key elements for Part 2. 1. Opening with the final day of trial. 2. Garrett's last desperate move. 3. Judge Mercer's comprehensive ruling. 4. The 100% asset award under California Family Code Section 2625. Referrals to DA and U.S. Attorney 6. Lane State Bar Referral 7. Aftermath. Knox Cooperating 8. Unresolved thread with DL 9. Partial justice. U.S. Attorney declines. DA accepts misdemeanor 10. Stinger. New case file with DL connection. I need to follow the formatting rules. Asterisk. No character. Format for dialogue. Asterisk. Attribution after dialogue through action / context. Asterisk. 3. CT as bold. Asterisk. Maintain tension every 2 to 3 paragraphs. No forbidden words. Add 3 to 5 physical confrontation / humiliation scenes. Let me write this continuation. Show more. Done. The morning of day 11 arrived with fog rolling through downtown Los Angeles, softening the hard edges of the courthouse towers. Marlene stood at her apartment window at 5:45, coffee cooling in her hand, watching the gray light seep between buildings. Today, it ended. 14 months of litigation. 3 years of documentation. 15 years of marriage reduced to a judge's ruling. She dressed in the same plain navy blazer she'd worn throughout the trial. No jewelry except the wedding band she'd removed tonight, regardless of the outcome. Hair pulled back, makeup minimal. The uniform of a woman who'd learned that invisibility could be a weapon. Victor called at 7. Mercer's clerk says he's been in chambers since 6. That's unusual. He's preparing something comprehensive. You sound confident. I'm prepared. Confidence is a byproduct. She drove to the courthouse through thinning fog, parked in the structure across the street, and walked through security with the badge she no longer needed to hide. The guards recognized her now, the federal agent who'd dismantled her husband on the stand. One of them nodded with something like respect. Courtroom 4B was already filling when she arrived. More reporters than yesterday. More spectators. Word had spread about the IRS agent and her fraudulent husband, and Los Angeles loved a good downfall story. Garrett sat at the defense table with Lane beside him. He looked like he hadn't slept. Gray skin, red eyes, suit slightly wrinkled for the first time in the entire trial. Miranda Cole was notably absent. The affair partner had apparently decided that sinking ships weren't worth standing on. Lane leaned close to Garrett, whispering urgently. Last-minute strategy, desperate measures, whatever plan they'd constructed overnight to salvage something from the wreckage. Victor arrived and took his seat beside Marlene. "You ready?" "I've been ready for 3 years." The bailiff called the room to order at 9 sharp. Judge Mercer emerged from chambers with a folder thick enough to suggest comprehensive findings. He settled into his chair, adjusted his glasses, and surveyed the courtroom with the gravity of a man about to deliver judgment. "This court is now in session. Case number BD20247881, Ashford versus Ashford." He opened the folder. The room held its breath. "Before I deliver my ruling, I want to address what this court has witnessed over the past 11 days. Mercer looked at Garrett directly. "Mr. Ashford, you entered this proceeding with a simple narrative. Your wife was financially illiterate. She contributed nothing to your success. She deserved minimal consideration in the division of assets you claimed were worth approximately $2.387 million. He paused. Let the number hang in the air. That narrative was a lie, deliberately constructed, systematically presented, and supported by fraudulent documentation you attempted to introduce as evidence." Lane shifted in his seat. Garrett stared at the table. "Your wife, whom you dismissed as a government clerk, is a GS-14 special agent with the Internal Revenue Service Criminal Investigation Division. She has spent 17 years investigating exactly the kind of fraud you committed, and she documented your hidden assets with a thoroughness that would impress any prosecutor in the country." Mercer turned a page in his folder. "The evidence presented by the petitioner establishes the following. You concealed approximately $8.717 million in community assets across accounts in the Cayman Islands, Switzerland, and the British Virgin Islands. You filed false financial disclosures under penalty of perjury. You submitted a forged document to this court in an attempt to deny your wife her lawful share of marital property." The words fell like hammer blows, each one a nail in Garrett's financial coffin. California Family Code Section 2602 provides that when a party has deliberately misrepresented assets in a dissolution proceeding, the court may award 100% of undisclosed assets to the innocent party. 100%. Marlene kept her expression neutral. Beside her, Victor's pen stopped moving. Additionally, California Family Code Section 1101 establishes that a spouse who breaches fiduciary duty by concealing assets may be liable for the entire value of those assets, plus attorney's fees and costs. Mercer removed his glasses, cleaned them slowly. The theatrical pause of a judge who understood the weight of his next words. This court finds as follows. The ruling took 47 minutes to read. Mercer walked through each hidden account, each shell company, each wire transfer that contradicted Garrett's sworn testimony. He cited statute numbers and case precedents with the precision of someone who'd spent the previous evening ensuring his ruling would survive appeal. Garrett sat motionless through most of it, but when Mercer reached the asset division, something broke. All disclosed marital assets, totaling $2.387 million, are awarded to the petitioner. Garrett's head dropped slightly. All undisclosed marital assets, totaling $8.717 million, are awarded to the petitioner. His hands gripped the table edge. The marital residence at 1847 Pacific View Drive, Pacific Palisades, is awarded to the petitioner. A sound escaped him, half groan, half sob. All retirement accounts, investment portfolios, and business interests acquired during the marriage are awarded to the petitioner. Lane put a hand on Garrett's arm. Restraining or comforting, impossible to tell. Additionally, this court imposes sanctions of $50,000 against the respondent under California Code of Civil Procedure Section 128.7 for submitting fraudulent documents. These sanctions are payable to the petitioner within 30 days. Mercer set down one page and picked up another. Furthermore, this court finds sufficient evidence of criminal conduct to warrant referral to appropriate authorities. He looked at Garrett with an expression that mixed contempt with something almost like pity. This matter is hereby referred to the Los Angeles County District Attorney for potential prosecution under California Penal Code Section 118, perjury. Additionally, this matter is referred to the United States Attorney for the Central District of California for potential prosecution under Title 26, United States Code, Section 7201, tax evasion. Lane stood suddenly. Your Honor, we object to the criminal referrals. My client has cooperated with— Your client submitted a forged document to this court, Mr. Lane. Your client lied under oath about assets he knew existed. Your client attempted to defraud his wife of millions of dollars while publicly calling her financially illiterate. Mercer's voice carried steel. Sit down. Lane sat. One final matter. Mercer turned to a fresh page. This court is also referring counsel for respondent to the State Bar of California for potential violation of Rule 3.3, candor toward the tribunal. The forged document introduced as Exhibit 27 was certified by counsel as authentic. Either Mr. Lane knew the document was fraudulent, or he failed in his duty to verify evidence before submitting it to this court. The State Bar will determine which. The courtroom was absolutely silent. Mercer closed his folder. This court's ruling is final. The marriage of Marlene Ashford and Garrett Ashford is hereby dissolved. All orders are effective immediately. The gavel fell. It was over. If you've made it this far, you're clearly invested in this story. Hit subscribe and the notification bell. The aftermath gets even more intense. The courtroom erupted into controlled chaos the moment Mercer left the bench. Reporters rushed toward the bar, shouting questions. Spectators murmured to each other with the satisfied tone of people who'd witnessed something historic. Garrett remained seated, staring at the table, processing the reality that he'd just lost everything. $11 million, his reputation, possibly his freedom. Lane gathered his papers with mechanical movements. His career wasn't over, but it had just taken significant damage. A state bar referral for fraud on the court would follow him for years, even if he ultimately avoided sanctions. Victor turned to Marlene with an expression that mixed professional satisfaction with personal awe. 11 million? Plus the sanctions? Plus the house? Plus the criminal referrals? How do you feel? Marlene considered the question. 14 months of litigation, 3 years of documentation, 15 years of marriage. I feel finished. She gathered her own materials, the folders that had contained her evidence, now mostly empty after being entered into the court record. The badge that had changed everything when she'd finally revealed it. Movement caught her eye. Garrett was standing now, Lane's hand on his arm, being guided toward the side exit that would let him avoid reporters. But Garrett stopped, turned, looked at Marlene with eyes that held fury and devastation in equal measure. He crossed the courtroom in 3 long strides. Lane called out, warning or restraint, but Garrett wasn't listening anymore. You did this. The words came out rough, broken. He stood 3 feet from her, close enough that Victor shifted position protectively. You destroyed everything, my business. My reputation, my life. You destroyed those yourself, Garrett. I just documented it. Documented, he spat the word. You spied on me. For 3 years, you pretended to be— I pretended nothing. I was exactly who I always was. You just never bothered to look. His hand moved fast, faster than Victor could react, faster than the bailiff across the room could intervene. He grabbed her arm, fingers digging in hard enough to bruise. You're going to regret this. You think you won? You think taking my money makes you the winner? Marlene didn't pull away, didn't show pain, just looked at him with the same calm she'd maintained throughout 3 years of documentation and 14 months of litigation. Let go of my arm, Garrett. Or what? You'll have me arrested? Add assault to the charges? I'll remind you that there are 14 witnesses in this room, 3 of them reporters with cameras, and a bailiff who's already moving toward us. You've lost $11 million today. Do you really want to add assault charges to your problems? His grip tightened for a moment, one last assertion of physical control over a situation he'd lost completely. Then, reality penetrated. He released her arm, stepped back. This isn't over. Yes, it is. The bailiff arrived, positioning himself between them. Lane grabbed Garrett's elbow and pulled him toward the exit with desperate urgency. Victor moved to Marlene's side. Are you all right? She looked at her arm. Red marks where Garrett's fingers had dug in. They'd bruised by evening, evidence of his final, futile assertion of power. I'm fine. That was assault. We should report. He grabbed my arm in front of 14 witnesses and 3 cameras. The footage will be online within the hour. That's report enough. She picked up her briefcase, walked toward the main exit. Victor followed, still processing everything he'd witnessed. Outside, the fog had burned off. Los Angeles spread before them in harsh sunlight, the city where Garrett Ashford had built an empire on hidden money and public lies. That empire was rubble now, and Marlene was walking away from it with everything he'd stolen, everything he'd hidden, everything he'd thought his wife was too stupid to find. The news broke within hours. IRS agent wins landmark divorce, husband's $11 million fraud exposed. Federal agent documents, husband's hidden offshore accounts, awarded 100% of assets. Los Angeles developer referred for criminal prosecution after wife reveals hidden fortune. Marlene's phone buzzed with media requests she ignored, congratulations from colleagues she acknowledged briefly, and one message that mattered more than the others. From her supervisor at IRSCI. Saw the news. Proud of you. Take whatever time you need. Your desk will be here when you're ready. 17 years of service. They knew what she'd done wasn't investigation. It was survival. They respected the line she'd maintained between personal and professional, even when crossing it would have been easier. She spent that evening in her modest apartment, packing boxes she no longer needed. The marital home was hers now, 6,000 square feet in Pacific Palisades, worth more than she'd make in a decade of federal salary. She'd sell it, take the money, find something smaller, something that didn't echo with 15 years of systematic diminishment. The wedding band came off at sunset. She held it up to the light, simple gold, purchased when Garrett still pretended to love her and she still pretended to believe him. It had cost $800 in 2009. It represented nothing now except the legal requirement that had kept it on her finger until today. She set it on the windowsill, let it catch the dying light, then went back to packing. 3 weeks later, the first domino fell. Chandler Knox, CPA, Garrett's accountant, the architect of the Cayman structures, the man who'd written "delete this" after reading on an email that became evidence, accepted a proffer agreement with federal prosecutors. The news arrived via her former colleagues at IRSCI, who were now officially investigating matters she'd uncovered personally. Knox is cooperating, Marcus Riley told her over coffee. He'd been her partner on a dozen cases before her marriage imploded and her cases got reassigned. Full disclosure, client lists, account structures, everything. How many clients? 47 high-net-worth individuals with offshore accounts matching the patterns you documented. 47 people. Billions of dollars in hidden assets. All because she'd found one misfiled envelope in her husband's desk. That's not my investigation anymore. No, but it wouldn't exist without you. Marlene stirred her coffee, thought about the ripples spreading outward from one act of documentation. What happens to Garrett? Knox's cooperation complicates things. Defense attorneys will argue that Knox was the mastermind, that clients like Garrett were following professional advice without understanding the illegality. Marcus shrugged. The U.S. attorney is still evaluating. Could go either way. And the state charges? The perjury? DA's office is more aggressive. They're pushing forward. Preliminary hearing is scheduled for next month. Small victories. The federal system moved slowly, prioritized carefully, sometimes declined cases that seemed obvious. The state system had different pressures. Elected district attorneys who liked headlines about rich people facing consequences. Knox's client list, Marlene said. Did you find anything interesting? Marcus studied her face. Why do you ask? There was an email in Garrett's files. Referenced someone with initials DL. Talked about the other arrangement. I never identified who it was. DL. Marcus pulled out his phone, scrolled through notes. Nothing jumping out, but the investigation's still expanding. We're finding new names every week. Keep me posted, off the record. You're not supposed to be involved anymore. I'm not involved. I'm curious. He smiled slightly, the expression of someone who knew Marlene well enough to understand that her curiosity had cracked larger cases than this one. I'll let you know if DL surfaces. The preliminary hearing for Garrett's perjury charges took place 6 weeks after the divorce was finalized. Marlene attended as a spectator, not a witness. Sat in the back row of a different courtroom, watching her ex-husband's legal troubles compound. Deputy District Attorney Sarah Whitfield presented the evidence with clinical efficiency. The financial disclosure, signed under penalty of perjury. The testimony from the divorce trial. The documentation proving those statements were false. Garrett's new attorney, Lane had withdrawn citing conflict of interest, argued that the statements were made on advice of counsel, that Garrett believed his disclosures were accurate based on information provided by his accountant. The defendant signed these documents personally, Whitfield countered. He certified their accuracy under penalty of perjury. Reliance on professional advice may be a factor in sentencing, but it doesn't negate the false statements themselves. The judge found probable cause to proceed. Trial scheduled for 4 months out. More delays. More legal maneuvering. More time for Garrett to contemplate the consequences of lies he'd thought were safe. After the hearing, Marlene walked to the parking structure where her car waited. The same structure she'd used during her divorce trial. The same city that had watched her marriage disintegrate in public. Footsteps behind her. Quick. Purposeful. She turned, trained instincts never fully dormant, and found Miranda Cole approaching with fury written across professionally made-up features. You ruined him. Miranda stopped 3 feet away. Close enough to be threatening, far enough to claim she wasn't. I documented his crimes. He ruined himself. He loved you. For 15 years he loved you and you were spying on him the entire time. He hid $8 million from me while calling me financially illiterate in public. That's not love. That's contempt. You don't understand him. You never understood him. He was building something. He was stealing from the IRS, from the state, from me. Marlene kept her voice level. And you helped him. The emails, the transfers. Your name appears on documents, Miranda. You might want to worry about your own exposure before defending his. The color drained from Miranda's face. What documents? Corporate filings for Pacific Ridge Development. You're listed as assistant secretary, which means you certified certain statements about company finances, statements that turned out to be false. I just signed what Garrett told me to sign. I didn't know. That's what Garrett's saying, too. But someone knew. Someone made decisions. Someone moved the money. Marlene stepped closer. The federal investigation is expanding, Miranda. 47 clients. Billions of dollars. Everyone who touched those accounts is getting looked at. If I were you, I'd be talking to a lawyer instead of confronting me in parking structures. Miranda's confidence collapsed. The woman who'd mocked Marlene's clothes at dinner parties, who'd whispered about drowning, who'd helped orchestrate a campaign of public humiliation. That woman was gone. In her place stood someone beginning to understand that consequences had finally arrived. I can't afford a lawyer. Garrett isn't. He can't help me anymore. Then find a public defender. Apply for legal aid. Do something besides yelling at me. Marlene walked past her toward the car. I'm not your enemy, Miranda. I'm just the person who documented the truth. What you did with it was your choice. She drove away without looking back. In the rearview mirror, Miranda stood alone in the parking structure, reality settling over her like the Los Angeles smog. Miranda's not the only one facing consequences. Stay tuned. The investigation is about to blow wide open. 2 months later, the federal investigation produced its first indictment. Not Garrett, not yet, but Douglas Latham, initials DL, senior partner at a law firm that specialized in international asset protection, was arrested on 23 counts of conspiracy to commit tax fraud, money laundering, and obstruction of justice. Marlene read the indictment with professional interest. Latham had been the spider at the center of the web, the attorney who'd designed the shell company structures, facilitated the offshore transfers, and coached clients on how to hide assets from divorcing spouses and the IRS alike. His client list included Garrett Ashford. Also Gerald Hoffman, the attorney who'd witnessed Garrett's power of attorney for the British Virgin Islands accounts. Also 34 other names, some of them recognizable from business journals and society pages. Developers, investors, trust fund heirs, the comfortable wealthy who'd assumed their money made them untouchable. Marcus Riley called with details the news didn't include. Latham was the architect. Knox was the builder. Your husband was just one of many clients. How many are facing charges? Federal charges? 12 so far. More coming. The DOJ is treating this as a major white-collar prosecution. Press conferences, task force, the whole apparatus. And Garrett specifically? Silence on the line. Marcus choosing words carefully. The U.S. attorney declined to prosecute him federally. Marlene absorbed this. Not surprise. She'd expected the possibility. But something like disappointment regardless. Why? Insufficient evidence of willful intent, they said. Knox's cooperation muddied the waters. Defense attorneys would argue Garrett relied on professional advice, didn't understand the illegality of the structures. The case against Latham is stronger because he designed and promoted the schemes. Garrett was a client following advice. He knew what he was doing. Probably, but probably doesn't meet the burden of proof for federal prosecution. The resources go where convictions are likely. The federal system, rational, strategic, sometimes unjust in its prioritization. What about the state charges, the perjury? Still proceeding. D.A. Whitfield is aggressive. She wants the conviction. Small victories, partial justice. The system protecting itself while occasionally sacrificing individuals who'd become too visible to ignore. Marcus, did Latham have any other associates? Partners who might have been involved? Why do you ask? The email I found, the other arrangement. DL. Confirmed the transfer. Latham fits the initials, but the phrasing suggested someone else was involved too. Someone who knew about arrangements beyond just Garrett's accounts. More silence. Marcus thinking. There's a name that keeps appearing in the investigation. Nothing concrete yet, but patterns. References to someone called the facilitator in some of Latham's communications. Who? We don't know. The references are oblique, coded almost. Whoever it is, they were careful. More careful than Latham. Much more careful. Latham got sloppy. The facilitator didn't. Marlene filed this away. The investigation had exposed one layer of fraud. Beneath it, other layers remained hidden. Other arrangements, other facilitators, other money moving through channels designed to be invisible. Not her investigation, not her responsibility. But the curiosity remained. The professional instinct that had driven her for 17 years, that had led her to document her own husband's crimes, that wouldn't rest while questions remained unanswered. Somewhere, someone was still facilitating fraud, still moving money through shell companies and offshore accounts, still helping wealthy clients hide assets from taxes and spouses and anyone else with legitimate claims. That someone was still operating, still invisible, still out there. Garrett's state trial for perjury began 4 months after the federal indictments made headlines. The prosecution's case was straightforward: sworn statements that were demonstrably false, financial disclosures that contradicted verified bank records, testimony under oath that crumbled when confronted with evidence. The defense argued reliance on professional advice. Garrett had trusted his accountant and attorney. He'd signed documents without understanding their implications. He was a victim of professionals who'd misled him about the legality of their schemes. Dia Whitfield dismantled this argument methodically. Mr. Ashford signed financial disclosures that listed his net worth at $2.387 million. Bank records show he controlled over $11 million. He didn't misunderstand the difference between $2 million and $11 million. He lied. Garrett's attorney, a veteran criminal defense lawyer named Patricia Reeves, countered with character witnesses and arguments about complexity. My client is a real estate developer, not a tax specialist. He relied on professionals who told him these structures were legal. When those professionals proved to be criminals, as Mr. Latham's indictment demonstrates, my client became a victim, not a perpetrator. The jury deliberated for 3 days. Marlene attended the verdict reading, sat in the back row again, anonymous among spectators who didn't know she was the woman whose documentation had made this prosecution possible. The foreperson stood. On the charge of perjury under California Penal Code Section 118, we, the jury, find the defendant guilty. Garrett's head dropped. Patricia Reeves put a hand on his shoulder, comfort or restraint. On the charge of attempted fraud under California Penal Code Section 664 and 532, we, the jury, find the defendant guilty. 2 convictions. Not the federal charges that would have meant years in prison, but convictions nonetheless. Sentencing was scheduled for 6 weeks later. Garrett faced up to 4 years for the perjury alone, though first-time offenders rarely received maximum sentences. Outside the courthouse, reporters gathered around D.A. Whitfield for statements. Today's verdict sends a clear message. You cannot lie under oath and expect to escape consequences. Mr. Ashford thought his wealth and his attorneys would protect him from accountability. The jury disagreed. Marlene slipped away before anyone recognized her. The verdict was satisfying but incomplete. 2 state convictions, no federal charges. Latham would likely plead out and receive reduced time in exchange for cooperation. The facilitator remained unidentified. Partial justice, the best the system usually offered. She drove home to the small house she'd purchased after selling the Pacific Palisades mansion. 3 bedrooms instead of 7. A garden instead of a tennis court. Quiet instead of echoes. The settlement money sat in conservative investments, enough to live comfortably forever, more than she'd ever expected to have. She'd donated $100,000 to legal aid organizations that helped abused survivors navigate divorce proceedings. Another $100,000 to financial literacy programs for women. The rest waited while she decided what to do with a fortune she'd never wanted to need. Sentencing day arrived on a Tuesday in March. The courtroom was less crowded than the trial. Verdicts attracted attention, consequences less so. Garrett sat at the defense table in a suit that no longer fit properly. Prison awaited, and he'd lost weight anticipating it. Judge Harrison Chen reviewed the pre-sentencing report, victim impact statements, and arguments from both sides. His face revealed nothing about his inclinations. Mr. Ashford, please rise. Garrett stood. Patricia Reeves stood beside him. You've been convicted of perjury and attempted fraud, serious crimes that undermine the integrity of our legal system. You lied under oath in a divorce proceeding, attempting to deprive your spouse of millions of dollars in marital assets. Chen paused, adjusted his glasses. However, I must also consider mitigating factors. This is your first criminal conviction. You've cooperated with investigators since your conviction. You've lost your business, your reputation, and your financial resources as a consequence of your actions. Garrett's posture shifted, hope penetrating despair. Additionally, the court notes that the primary architects of the fraud schemes, Mr. Latham and Mr. Knox, are facing or have faced their own consequences. You were a client of these professionals, and while that doesn't excuse your lies, it does provide context. Chen delivered the sentence. For the charge of perjury, 2 years in state prison, suspended. You will serve 12 months of supervised probation with conditions including community service and financial restitution. Suspended sentence, no prison time. For the charge of attempted fraud, 18 months in state prison, suspended. You will serve an additional 12 months of supervised probation, consecutive to the first term. Garrett's shoulders sagged with relief. 24 months of probation instead of years behind bars. Additionally, you are ordered to pay restitution of $75,000 to cover the court's costs and investigative expenses. You are prohibited from serving as an officer or director of any corporation during your probation. And you are required to complete 200 hours of community service with organizations that provide financial education to underserved communities. The gavel fell. Garrett Ashford walked out of the courtroom without handcuffs. Convicted felon, but free. Destroyed financially, but not imprisoned. Marlene watched him leave. Patricia Reeves guided him past reporters who shouted questions he didn't answer. Victor appeared beside her. He'd attended too, invested in the outcome of a case that had defined his career. No prison time. Suspended sentence, probation, community service. She kept her voice neutral. It's more than a lot of white-collar criminals get. It's less than he deserves. Probably. But the system isn't designed to deliver what people deserve. It's designed to process cases efficiently and maintain the appearance of justice. Victor shook his head slowly. You're remarkably philosophical about a man who tried to steal $11 million from you. I got the $11 million. He got 2 felony convictions and a destroyed reputation. The federal investigation is still expanding because of what I documented. She stood, gathering her coat. Justice isn't always prison. Sometimes it's consequences. He'll never recover from this, not professionally, not socially, not financially. That's a kind of justice too. A kind. The only kind that's available most of the time. They walked out of the courthouse together. The last time either of them would enter this building for Ashford versus Ashford. Outside, spring sunlight warmed streets that had seen Marlene arrive as a plaintiff, reveal herself as a federal agent, and leave as something in between, victor and victim, survivor and strategist. What now? Victor asked. Now I go back to work. There are other frauds to investigate, other assets to trace, other patterns to recognize. After everything you've been through? Because of everything I've been through. She paused at the intersection, waiting for the light. This case taught me something, Victor. The system doesn't fix itself. It doesn't pursue justice automatically. It requires people who document, who persist, who refuse to accept lies as truth. People like you. People like me. People like you. People who do the work even when the outcomes are partial and the victories are incomplete. The light changed. They crossed together, then parted at the parking structure entrance. If you ever need anything, Victor said, call me. I owe you more than I can repay. You don't owe me anything. You took a case that better attorneys would have rejected. You trusted me when my documentation seemed too good to be true. You helped me get justice. Imperfect justice, but justice nonetheless. She shook his hand, the handshake of colleagues who'd been through something together and would never forget it. Take care, Victor. Take care, Marlene. She drove away from the courthouse for the last time. In the rearview mirror, the building shrank until it disappeared entirely, replaced by the endless sprawl of a city that created fraud and occasionally punished it. 6 months later, Marlene sat at her desk in the IRS Criminal Investigation Field Office. The walls held commendations she'd earned over 17 years. The computer displayed case files she'd been working since returning from leave. Her current investigation involved a real estate developer in Phoenix. Familiar patterns, offshore structures, beneficial ownership buried under layers designed to defeat scrutiny. One name in the file kept appearing, a silent partner referenced in emails and memos but never fully identified. Someone who'd advised on asset protection strategies for the development company. The references were oblique, careful. The phrasing suggested someone who'd learned from others' mistakes, from Latham's arrest, from Knox's cooperation, from the cascade of consequences that had followed Marlene's documentation of her own husband's fraud. She pulled up the federal case files, accessed with credentials she'd earned and maintained, cross-referenced the Phoenix patterns against known associates of Douglas Latham. One name emerged, a lawyer who'd worked at Latham's firm briefly before leaving to start an independent practice. Someone who'd handled special projects that didn't appear in billing records. Someone whose initials appeared in coded communications that prosecutors hadn't fully decoded. The initials, DM, not DL, that had been Latham himself. But DM, whoever they were, had been mentioned in the same communications. A junior associate, perhaps. A protege who'd learned the craft and gone independent before the firm's collapse. Daniel Morrison. The name appeared in state bar records. Licensed in California and Nevada, currently practicing out of Phoenix, the same city where Marlene's new investigation was centered. Coincidence seemed unlikely. She opened a new file, labeled it with today's date and a case number that hadn't been assigned yet. Began documenting. Daniel Morrison, protege of Douglas Latham, potential facilitator of ongoing fraud schemes, connected to a Phoenix development company that was exhibiting the same patterns Garrett Ashford had used. The work continued. It always did. Someone knocked on her office door. Marcus Riley leaned in. "Got something you should see." He handed her a printout. Financial records from the Phoenix case, obtained through legal channels that had taken weeks to navigate. "Look at page 3. She turned to it. Wire transfer records from a holding company in Nevada. Recipient account in the Cayman Islands. Same bank Garrett had used. Same structure Latham had designed. The authorizing signature on the transfer, D. Morrison, managing director. "It's him," Marcus said. "Latham's protege, running the same scheme with different clients." Marlene studied the document. Years of investigation compressed into a single page of evidence. "How many clients?" "We've identified 12 so far. There are probably more." "Phoenix Development Company?" "2 of their principals are on the list, along with investors from 3 other states." She set down the printout, looked at the file she'd just created on her computer. "I want this case." "Figured you would." "There's a conflict question. Some of these patterns connect back to Garrett's accounts, back to my divorce." "Legal reviewed it already. You're clear. The divorce is finalized, the marital assets are settled, and Morrison wasn't directly involved in your ex-husband's accounts. Any connection is investigative, not personal. No conflict, no barrier. Just another case to build, another fraud to document, another web of lies to unravel. Morrison's been operating for at least 3 years since Latham's arrest. He learned from the mistakes. He's more careful. Which is why we need someone who's equally careful." Marcus smiled slightly. "Someone who spent 3 years documenting her own husband's fraud without him ever noticing. That was personal. That was training, whether you meant it to be or not." He left her with the printout and the case file and the familiar weight of work that mattered. Marlene turned back to her computer, added the new evidence to the file, began mapping connections that would take months or years to fully understand. Daniel Morrison, the facilitator, the invisible man who'd learned from Latham's downfall and built something more sophisticated in its place. He was out there, moving money, hiding assets, helping wealthy clients defraud spouses and governments and anyone else with legitimate claims. He didn't know Marlene Ashford was looking for him yet. By the time he found out, it would be too late. The hunt continues, but that's a story for another time. If you enjoyed this one, drop a like and subscribe. More content like this is coming soon. The final pages of Garrett's story arrived in the mail 3 months after his sentencing. A form letter from the Superior Court notifying her that his probation had been modified. Community service hours completed early. Financial restitution paid. Supervised release converted to unsupervised. Good behavior. Early compliance. The system reducing its oversight of a man who'd learned to appear reformed. Marlene filed the letter with the rest of her divorce documentation. The folder had grown thick over 3 years of investigation and 14 months of litigation. It contained evidence of fraud, forgery, and systematic deception. It contained the story of a marriage that had been a lie from the beginning. It contained, ultimately, the truth. She closed the folder, placed it in a box with other closed cases, carried the box to a storage closet where old investigations went to rest. Garrett Ashford was over, his crimes documented, his consequences delivered, his name added to the list of cautionary tales that white-collar prosecutors use to warn future fraudsters. But the work continued. The Morrison investigation expanded weekly. New clients identified, new accounts traced, new patterns documented with the same methodical precision Marlene had applied to her own marriage. Some nights, she stayed late at the office, running searches and cross-referencing records. Some weekends, she brought files home to review while the small house settled around her. The work was who she was, had always been. Even during 15 years of marriage, even while Garrett dismissed her as a clerk, even while she documented his fraud and waited for the moment it would matter. Documentation was protection. Truth was power. Patience was strategy. She'd learned these lessons before she ever met Garrett Ashford. She'd applied them during their marriage. She'd used them to destroy him when destruction became necessary. Now she applied them to new cases, new fraudsters, new webs of lies that required dismantling. The Morrison file grew thicker, the connections multiplied, the evidence accumulated toward an eventual prosecution that would take down another architect of deception. Marlene worked late into evenings that stretched toward midnight. Coffee grew cold on her desk. The city outside her window cycled through its rhythms, traffic building, traffic fading, silence settling over streets that held their own secrets. She thought about Garrett sometimes, not with anger anymore. That had faded along with everything else the marriage had contained. Not with satisfaction either, though his downfall had been deserved. She thought about him with something closer to clarity, understanding, finally, what the marriage had been and what it hadn't been, what she'd gained from it, resources, experience, documentation skills she'd never expected to need personally. What she'd lost, years, trust, the belief that she could know someone fully. The losses mattered less now. Time had softened their edges. Work had filled the spaces they'd left behind. She was who she'd always been, an investigator, a documenter of truth, a patient destroyer of lies. The work continued. It always would. 1 year after her divorce was finalized, Marlene received an invitation to speak at a conference on financial crimes prosecution. The organizers wanted her perspective on documenting fraud, professional techniques, personal experiences, the intersection between the two. She accepted, prepared remarks that balanced case studies with broader lessons. Documentation isn't revenge, she told the audience of prosecutors, investigators, and law enforcement officers. It's protection. It's the difference between suspecting fraud and proving it, between believing you've been wronged and demonstrating it with evidence that survives courtroom scrutiny. She described patterns she'd observed over 17 years, the shell company structures, the offshore accounts, the professional enablers who helped wealthy clients hide assets from everyone with legitimate claims. These schemes survive because they rely on complexity and patience. Victims get overwhelmed by the structures. Investigators get frustrated by the barriers. The fraudsters count on everyone giving up before the truth emerges. She paused, looked out at faces that understood what she was describing. Don't give up. Document everything. Follow every thread. Trust the evidence, even when it leads to conclusions you didn't expect. The audience applauded when she finished. Afterward, younger investigators approached with questions about techniques and cases and careers in financial crimes prosecution. One of them, a woman in her late 20s, sharp-eyed and eager, asked a question Marlene had been expecting. Is it true you documented your own husband's fraud for 3 years before exposing him? Marlene considered the question, the personal and professional bleeding together, as they always did. Yes. How did you keep going? Living with him while documenting his crimes? I compartmentalized, kept the investigation separate from the marriage, at least in my mind, treated the documentation as protection rather than betrayal. But it must have been difficult, knowing what he was doing, pretending you didn't know. It was necessary. Exposing him before I had sufficient evidence would have meant losing both, the marriage and the prosecution. I waited until the evidence was undeniable. Then I used it. The young woman nodded slowly, processing what that level of patience actually required. Would you do it again? If you could go back? Marlene thought about the question carefully. The years of observation, the humiliation she'd endured, the documentation that had become her weapon. I would document sooner. Start the file the first time I noticed something wrong, not years later when the patterns were undeniable. But you'd still stay. You'd still document? Yes, because documentation gave me options that leaving immediately wouldn't have provided. By the time I exposed him, I had evidence that guaranteed outcomes rather than arguments that could be dismissed. Some people would say you should have just left. Some people don't understand how power works in marriages like mine. He controlled the finances. He controlled the narrative. He controlled what people believed about me. Leaving without documentation would have meant leaving without resources, without credibility, without any ability to hold him accountable. She paused, let the lesson sink in. Documentation changed that. It gave me power. Not emotional power. I didn't need revenge to feel complete. But legal power, financial power, the power to walk away with everything he'd hidden instead of nothing at all. The young woman thanked her and moved away. Others took her place with other questions about other cases. Marlene answered them all, shared what she'd learned, tried to transmit the lessons that had cost her 15 years to acquire. Documentation was protection. Truth was power. Patience was strategy. These were the principles that had saved her. They might save others too if she taught them well enough. The Morrison investigation concluded 18 months after Marlene first identified him. Federal prosecutors indicted him on 31 counts of conspiracy, fraud, and money laundering. His client list included 19 individuals who'd used his services to hide assets from the IRS and divorcing spouses. Marlene testified at his trial, professional testimony about patterns and evidence, delivered with the same calm she'd maintained throughout her own divorce proceedings. Morrison was convicted on 27 counts, sentenced to 12 years in federal prison. The facilitator had finally been found. But, as Marlene had learned during her own case, justice was always partial. Morrison's clients received varying consequences, some prosecuted, some negotiating settlements, some escaping accountability entirely through legal maneuvering and cooperative agreements. The system processed cases according to its own logic. Some people faced consequences, others didn't. The patterns repeated with new names and new schemes, requiring new investigators to document new frauds. The work continued. It always would. 2 years after her divorce, Marlene cleared out the last of her storage boxes. The divorce documentation went into a filing cabinet in her home office. 17 folders that told the story of a marriage, an investigation, and a destruction. She kept them because they were evidence of what she'd survived, of what she'd accomplished, of who she'd become through the process. But she didn't look at them often. The past was documented, not dwelt upon. The Morrison case files joined them, and the cases before that, stretching back through 17 years of investigations and convictions, and fraudsters who'd thought they were untouchable. Her career continued. New cases, new patterns, new documentation leading to new consequences for people who believed wealth made them invisible. She'd received promotions since her divorce, recognition for work that had expanded beyond her personal case into broader contributions to financial crimes prosecution. The IRSCI valued investigators who understood both the technical and human dimensions of fraud. Some nights, she still worked late. Some weekends, she still brought files home. The compulsion to document, to understand, to expose, it never fully faded. It was who she was. But she balanced it now, made time for things that had nothing to do with fraud or investigation or the systematic dismantling of lies. She traveled. Paris in spring, Tokyo in autumn, places she'd never visited during her marriage because Garrett had no interest in destinations that didn't advance his business. She reconnected with family, her sister in Chicago, her parents in Atlanta, relationships that had atrophied under Garrett's control, now rebuilding through visits and calls and the slow accumulation of presence. She dated occasionally. Men who didn't remind her of Garrett, quieter, more curious, more willing to ask questions instead of assuming answers. Nothing serious yet, but nothing urgent either. Time had become hers again, after 15 years of sharing it with someone who didn't deserve it. The settlement money remained largely untouched. Invested conservatively, generating returns she didn't need but appreciated having. Security against futures she couldn't predict. She thought about Garrett less frequently as years passed. He existed in news articles occasionally, the disgraced developer, the convicted fraudster, the cautionary tale. He'd attempted comebacks that failed, ventures that collapsed, rehabilitations that convinced no one. His punishment continued long after probation ended. The consequences of exposure stretched infinitely forward, touching every business opportunity, every social relationship, every attempt to rebuild what documentation had destroyed. That was justice, too. Not the dramatic kind, not prison cells and orange jumpsuits, but the persistent kind, the ongoing erosion of everything he'd valued. Marlene had taken his money, his reputation, his assumption that she was too stupid to matter. What she'd left him was truth, the inescapable, documented truth of who he was and what he'd done. Sometimes that was worse than prison. The story ended as it had begun, with documentation. Marlene sat at her desk on a Wednesday afternoon, reviewing a new case file. A financial services company in San Diego. Patterns that suggested asset concealment. A CEO who believed his structures were sophisticated enough to defeat scrutiny. She'd prove him wrong. Eventually. With patience and persistence and the methodical accumulation of evidence that turned suspicions into convictions. But that was future work. Stories that hadn't been told yet. The story that had been told, Garrett and Marlene, the developer and the agent, the fraudster and the documenter, was finished. Documented in court records and news archives and folders that sat in filing cabinets, rarely opened, never forgotten. She'd been called a clerk who couldn't balance a checkbook. She'd responded by documenting $8 million in hidden assets, exposing fraud that led to criminal convictions, and walking away with everything her husband had stolen. The response was proportional. The documentation was thorough. The consequences were deserved. That was the story. Complete, now. As complete as any story ever was. Marlene closed the current file, looked out her office window at a city that contained multitudes, fraudsters and investigators, liars and truth-tellers, people hiding assets and people documenting the hiding. She was one of the latter, had always been, would always be. The work continued. It always would.
Thank you for taking the time to watch this video today. If you found the content helpful, please remember to like and subscribe so you won't miss our upcoming episodes. If you have any questions or suggestions, feel free to leave a comment below. We are always here to listen.